So the question of whether international law is really law or how much international law matters often boils down to this question of enforcing international law, right? And the idea is pretty straightforward. If we can't enforce law, is it really law, right? The entire definition of law is that the same thing always happens in the same circumstances, right? Or that the same kind of behavior leads to the same kind of consequences, right? Domestically, that relies on law enforcement, right? We have police who investigate crimes, they apprehend suspects, we have prosecutors who bring charges, we have what we hope are impartial judges and juries to decide the cases, and we have a penal system to impose penalties, right? Now, we know even in the domestic situation that doesn't always work exactly the way we think it ought to. But international law has none of these, right? So the question a lot of people are going to raise is if there's no enforcement, how can we take international law seriously? And I'm going to try to make the case that we should take it seriously. Because the central point is that there are costs to breaking international law, even if you get away with it, right? And this, of course, is a central argument that the Constructivists have made that we've been talking about since the beginning of the course. And it focuses on the importance of norms. And in this respect, international law are sometimes thought of as being backed by international norms. Are these norms always obeyed? Clearly the answer is no, right? We already mentioned the case of Israeli occupation of the West Bank. We know that Russia annexed Crimea despite the fact that it's clearly illegal and the whole world said so. But the point is they've paid a big price for those things. Russia has been subject to economic sanctions. Israel has been subject to immense criticism and probably had a lot fewer opportunities for interaction and trade over the past 50 years because of its policies. So the point is there are costs to violating international law, even if that's not sufficient to undo the crime, right? Just as domestic law enforcement doesn't eliminate all crime or undo crime once it's been done, it does presumably create some incentives not to do crime. And that would be the point that constructivists would make about international law and advocates of international law make, which is states pay a price for violating it, and so there is some deterrent effect, though if somebody really wants to do something, it's not going to stop them. An important part of that deterrent, people will argue, is that a lot of norms, you might want to break it now, but there's a recognition that it serves your interest, that it could serve your interest later. So you think about the laws of war. Why did states after World War I stop using poison gas in war? Well, part of the argument is, but there was a treaty, of course. They signed a treaty that said they wouldn't. But of course, treaties get violated all the time. And the argument was everybody basically has mostly abided by that limit because there was a recognition that if we start using chemical weapons, for example, in World War II, which nobody did, right, others can then use them against us. And so there was this sense of it's in our interest to promote and protect that norm. Similarly, this has been an interesting case in the U.S. campaign against global terrorism. In the Bush administration and subsequently, the U.S. started using a set of procedures that the U.S. called enhanced interrogation. It's a nice way of saying torture. One of the opponents to using torture in many cases was the United States military itself, because they basically believed that the laws of war prohibited torture, but because the military in particular realized that there were going to be times in the future when its soldiers were going to get captured by other forces, that to protect its own soldiers, it had a very important interest in preventing the U.S. From using torture against terrorist suspects in the here and now. They actually ended up losing that battle, but perhaps there would have been even more torture if the U.S. military hadn't been opposed to it. So this is the constructivist position on norms, right? Is that norms don't overrule interests, but they may shape the definition of interests, right? States like to see themselves as following the law, right? And it contributes to their identity that they like to have as we're good guys. And there's also the interest that comes along with soft power, right? The idea is you want others to see you as being a good guy or as not being a bad guy, because that actually brings benefits to you down the road. So it's not that law will prevent somebody from doing something they want to do necessarily, but it might raise the price of doing it, or get states to think that they'd like to find a different way of approaching the problem. In important respects, we can think of international law as coordination, not about what it prohibits states from doing, but about what it allows them to do, because they're able to coordinate their activities with one another. So, for example, in the field of business and economics, the World Trade Organization is partly about prohibiting states from doing certain things, but it's also about facilitating the immensely complex movement of trillions of dollars of goods, right, and millions of items or billions of items of goods around the world every year. That makes everybody happier. Communication, this is a kind of a trivial example, but the illustration or the principle is important, right? How is it that we're able to send letters and packages and so on back and forth around the world? It's because there's a thing called the International Postal Union that makes sure when you send a postcard from Germany or wherever you've gone on vacation that it actually gets handed over to the Americans, and the Americans will keep on carrying it to its final address, even though the stamps are German stamps. Similarly, the Non-Proliferation Treaty coordinates the verification, the inspections of nuclear stations all over the world, that allows states to say, or to reassure themselves that other states aren't building nuclear weapons, and so they don't have to do it as well. So this is an important analogy then, that international law is more like domestic contract law than domestic criminal law, which is to say, oftentimes you don't want to violate a contract because doing so will rupture a beneficial business relationship. And so a lot of international law, people are going to argue, is like that. Yes, you could violate it, but then whatever it is you were getting out of that deal is going to go away. And so again, this is the notion of the law being self-enforcing. So again, I want to focus on coordination and the idea that everybody's that coordination that is in mutual interest turns out to enforce itself. Classic example is about driving, which side of the road you drive on. You know, in Britain they drive on the left. In the United States we drive on the right. That doesn't matter so much as long as, right, you follow the rule of the country that you're in. And regardless of what I think about driving on the right, if I go to a place where the rule is drive on the left, I don't have much incentive to violate that rule, do I? Because we know what happens. And actually, here's a funny picture of what happens. This is in Sweden, what was called Dagen H. When Sweden actually, in September of 1967, they switched. They used to drive on the left. They said, now we're going to start driving on the right. Doesn't matter which it was, as long as you agree. And when they first started out, of course, this is what you got, is chaos. So coordination is really important because in many cases, when you don't coordinate or when coordination breaks down, you get chaos, and nobody has an incentive for that. We will investigate this notion of coordination and self-enforcement with a bit of game theory in the next lecture.